Right, Abusiami mo bibi akwaba mfambra 2K News and Blossom on YouTube so I say Abusian for ya bane de nature say as usual munim eye update ahodo ayen sahaka Abusian yen kwa yentimi entina so sa no ane ye de aba say de abesom obi biara ohwe eye 2K News and Blossom eye YouTube channel yi na message wa dar mo bu ne ndie kwa so ye be kwani akwa akwa video no wo comment bia no ama comment ne ho ate e ama meche say e medi di atem emba o comment nim Sanso ana owi awadare mo boni ndi kwa so no ahye amofoforo nso enya ensema hodo a ekoso ni bi eti na bibia nso etimi aye kama abusuafo ebeko ni akwa akotie ensem ni akwa akohe video no ede aba meso so awadare ma obuo ni ndi kwa so obo he video ede akwa akosi na ma bibia nso etimi aye kama abusuafo me pese me kase be tentenko nko video ni famra.
The more I read the judgment, the more I became embarrassed. What I noticed is that the Supreme Court sought to rewrite the Constitution under the guise of interpretation. And they have no such jurisdiction. They have no jurisdiction to rewrite the Constitution as they purported to have done the last time that this matter was in court or per the ruling. Why? The Supreme Court, in my view, acted unconstitutionally.
How can it?
It can. Because the Supreme Court itself is under the Constitution. And the Supreme Court cannot give an interpretation which is not born out of the Constitution. So when the Supreme Court gives an interpretation that is not born out of the Constitution, that is unconstitutional. And I've heard the Attorney General say that the law is what the Supreme Court says it is. You heard him say that. And I cringed. The law is what the Supreme Court says it is if it is born out or is envisaged by the Constitution. The Supreme Court is not higher than the Constitution. So today, there is no way. If the judges in the Supreme Court, all of them sleep and wake up and say that we want to make a ruling that all men in Ghana are women and women in Ghana are men, and they agree at their conclave, and then interpret the Constitution, a portion of it or a provision of it, and say, so it is. That cannot happen. In other words, the Supreme Court cannot on its own decide that, even though the words are clear, who will say it is like this? I don't know whether you are following me. The Supreme Court has no such power. They have no such power. The Supreme Court, I've said time with our number, and people, you see, people, we have made it look, and the Attorney General has also helped in that. We have made it look like the Supreme Court can say what it wants. Never. The Supreme Court itself is a creation of this Constitution. And so it's under it. First and foremost, was there even an issue of interpretation? There wasn't. The words are very clear. But they went ahead to interpret and said that the fact that you pick a nomination form does not mean that you are joining a political party. And I asked myself, you are joining a political party different from the vehicle that brought you in. And I asked myself, can I, who is known to be an NDC, just walk into the NPP constituency office and pick a form and say I'm going to contest for NPP candidate? Can I just do that? Before you pick the form, you must have first joined them. I'm saying it again. Before you pick a form and even go for nomination, you must have first satisfied the conditions of being a member of the party before you can pick the form. So, let's take the speaker, the deputy speaker. Isiama was independent.
Now going
for party.
Party, yes.
What it simply means is that the NPP have satisfied themselves that he's now their member. That's how come he can pick a form. And what is the Supreme Court saying? That even when you file your nomination, it doesn't mean that you have crossed carpet. How is that possible? This is a program. Ordinary Ghanaians are listening. So me, I don't like quoting article this.
You like to go ordinary?
Ordinary.
Okay. So let me just refer you then. Because despite the existence of the provisions in the NPP's constitution, which makes it automatic and very clear that if you take certain actions, pursuant to, then you forfeit your membership, thereby meaning that ideally you shouldn't be representing the same party in parliament. When you come to the national constitution, in this judgment, the Supreme Court says in its own estimation that there is no doubt that rival meanings have been placed on the provisions of Article 97 1G and H of the 1992 Constitution by the Speaker's statement on the floor of Parliament, and the plaintiff thereby displacing all lingering doubts that this is a proper case for invoking the original interpretative jurisdiction of the Supreme Court as so established. That clearly means that in the mind of the Supreme Court, they feel this is in their domain.
I disagree with them because we all did interpretation at the law school, including them. You give words their ordinary meaning first. Give words their ordinary meaning first. The meaning on the street of Accra. Give those words that meaning first. And if it leads to absurdity, then you can now bring in a secondary meaning. Didn't we do all this in the law school? Give these words that you have read, give them their ordinary meanings, and let's see whether there will be absurdity.
Shadrach, put Article 97.
You put them, read it.
Put them on the screen so that everybody will see.
And we see whether it would lead to absurdity. You don't just jump into the middle and then start saying that you want to interpret. For what reason? Those words, and I said, and Justice Tanko has also reiterated that point, this judgment will not stand the test of time. And you know what they have done? They have effectively struck down Article 97. Article 97, the question is, when will it ever be relevant the way they have done it? When will we ever, when will we ever say that per Article 97, a minister, a member of parliament has crossed carpet? They have effectively done away with it. They've made it useless.
They've rather given it a meaning they deem fit.
And I'm saying that let's follow their meaning. When we follow their meaning, when will this article ever be invoked? It will never happen. It will never happen. See, I was here the last time and I asked the question, what did the speaker do for the writ to be filed against him? And it is true. The majority side admitted that the writ was filed on the 15th. Speaker's action was on the 17th. So the writ preceded the speaker's action. So what are you calling on the speaker? What are you calling on Parliament, on Supreme Court to do? There was nothing before the Supreme Court.
What was the reason for the writ on the 15th?
Because what Afenyo Markin is seeking to say is that the speaker's pronouncement must be declared null and void. On the 15th, the speaker didn't make any pronouncement for God's sake.
So you're saying what? He was only acting on speculation on a campaign platform?
Supreme Court doesn't take speculations.
So what are you saying?
I'm saying that there was no course of action. A course of action has not arisen. See how they try to meander their way out of it. There was no course of action. Now, one would have expected that now that the speaker had made a pronouncement on the 17th, per the Supreme Court rules, you can amend your writ. One would have expected them to amend their writ to reflect the complaint they have. They didn't amend their writ. So what was the Supreme Court going to determine when speaker had not yet, as it were, spoken? That's another flaw. Another flaw. You see? So there are a lot of flaws in this judgment, and it is not helpful to our democracy. And I tend to agree with my senior Chikata that coup d'etats are not only carried out by men in uniform, but they can also be carried out by men and women in wigs and gowns. You know? So, you look at all these things, then you begin to think that the building blocks of our democracy are being chipped away gradually, and at the end of the day, we will not have a democracy. This is not how I expected the Supreme Court to conduct itself. And I agree with Justice Tanko that a future Supreme Court, differently composed, would overturn this.
I see. Very interesting. Lawyer Makobodo, at the end of the day, practical lessons that we can all learn from this, and then making those deductions from this judgment also means that we've come to a position where a member of parliament could take an action to stand on the ticket of another party or as an independent candidate whilst in the present parliament, and will be made to represent his party irrespective of whether he's competing against them or not, or whether his party's own constitution goes against his actions he's taking. Is that right?
Thank you very much, and thank you to your viewers. Good morning to your viewers and listeners. I tend to want to pick something from what my brother Maliba said, which is to simplify the issues for our viewers and listeners. And drawing from that, I want to latch onto this analogy that if you're employed and you serve your letter of resignation to take effect 3 months from that time, does it take effect from then, there and then that you said your resignation? It doesn't. Obviously, your boss will be knowing that this person is not something we should be planning ahead with.
I don't understand. When it's stated in the code of conduct that when I take an action, I forfeit my employment status?
Yes, but in your employment status, it is in lieu of your salary, isn't it? So you normally have to give them ample time for which it will take effect. If you don't do so, you miss your salary. Is that not so? And you're supposed to give them that. In that analogy, is it the case that what they did was to commence there and then? And my brother gave an example of Hobson Adoye and Co. What these people did was to say that in this coming election, we are standing on either going independent or standing on this ticket.
That's what we're talking about.
Exactly. It doesn't mean that they were saying that here and now. I have stopped. I'm no more a member of parliament. That's not what they said, is it?
Are you saying?
And I'm giving another analogy. Let me give you another analogy.
Are you saying
listen.
that Alan Tremantin?
No, don't do that. Don't do that.
Alan
you allow everyone to talk.
Yes.
So let me talk.
No. Okay. So
let me talk.
Are you saying that?
No, let me talk. I haven't finished.
No, lawyer.
Don't do this. Don't do this. Don't do it. Don't do it.
Let me make this.
No. Don't do it, please. This is the only time I'm getting angry on this show. Don't do it.
That's fine. Go ahead.
You allow everyone to make their point.
Okay,
you won't allow me to.
Go ahead.
Why am I here?
Go ahead.
Please. In the same version, when you file for a divorce, that is formal, going to court. Does that divorce, because you have served it on your husband or wife, take effect from that moment in time? Would you not allow the court to go through the due process, then the court to pronounce on that? Is that not what happens? Why is it that for political purposes, we are now reading other meanings into this to say that now the Supreme Court judgment, we are ashamed of it. Copious legal principles being alluded to here. We are not saying we are even ashamed of it. And that there's a coup d'etat that can be done by men in suit. The first coup d'etat in this instance that was done by another man in suit in another house, which is Parliament. And that we were happy with that.
What did they do?
For you take a decision that changes the how Parliament is constituted, the business that could be done, and the Supreme Court takes steps to solve that problem. We can decide not to be happy with that or agree with that. Everyone is allowed to do that. In fact, when we go back to our classrooms, it is in discussions, commentaries, articles, so on and so forth, that has been written on a judgment like this, that we will teach. And there's no denial of the fact that there are dissenting views or minority decisions that eventually becomes majority decisions. Eventually, Lord Justice Denning in UK kept it. It was so much so that he was descending. Eventually, his position now becomes what is adopted by the same court. He eventually differently constituted years later. So there's no denial of that fact. Okay? But for now, this decision simplifies the issues, solves the problems, and we can now go further. We cannot say that the persons who said that in the coming election, I am going to stand on this ticket, has definitely now become an MP of that party. The people haven't even exercised their vote yet. Is it automatic that the moment you now say I'm crossing over to this side, you are now an MP in this current Parliament? That was the main issue. So once we are breaking it down, let's break it down for everyone to understand. Okay, that we're dealing with the 8th Parliament. The court was of the view that these individuals in the 8th Parliament are saying that we belong here. They haven't resigned. They're saying that in the coming election, we will stand differently. It doesn't even make them an MP in the coming Parliament, because the coming Parliament doesn't even exist. They still have to submit themselves to the constituency for the constituency to have a say. There are instances where people will even file their nomination in the same party and the constituency will change it. There are several people who have lost elections and it's been changed. You see, so let's not.
Can I ask a question now? Can I ask a question?
Yeah, behaving as if now I have become.
Can I ask a question?
How is the question? Sorry for flying.
So, respectfully, when we have the wording in Article 97(1), a member of Parliament shall vacate his seat in Parliament. Then you go to G, it says if he leaves the party of which he was a member. So the first instance you were, the Constitution said if you were, if he vacates from a party where he was, and subsequently decides to join another party or seeks to remain in Parliament as an independent, what do you think the framers of the Constitution were alluding to? Were they talking about a future Parliament or a current Parliament?
Okay.
Were they thinking the member of Parliament was already or still a member of his party, even though they made reference was a member of at the time of his election?
Okay. So thank you again. Let's look at Article 93 to begin with. 93 says that there shall be a parliament in Ghana, which shall consist of not less than 140 elected members. 2, subject to the provisions of this constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this constitution. Now, so it's not that another view which has been trumpeted that they are masters of their own and whatnot. Parliamentary power, which is vested in Parliament, has to be exercised subject to the provisions of this constitution. Now let's go into the question you gave. a member of parliament shall vacate his seat. That means that he shall vacate his seat. It's not that someone has to pronounce on whether he should vacate his seat or not. If that is supposed to happen, that power now goes to Article 99, where a court, public constituted, will be a high court based on the fact